We're here at the SmartFlow Compliance Summit 2016 talking piracy with Guy Ruttenberg of Ruttenberg IP Law. As someone who specializes in IP law, what do you see as the biggest challenges U.S. companies face in prosecuting software piracy in China?
First, you have to identify it, right? Identify who it is, where it is. Specifically, what are they actually copying? What are they actually using? How are they misappropriating the software? Second one is proving it. You might know because of the evidence you've collected on your own computer, or you might have a hunch. You actually have to prove it. Something that can stand up in a court of law or in a negotiation. And then the third one, obviously, is stopping it.
Guy, why do you think piracy is such a problem in China?
Yeah, I think there's a few different reasons. Some of them historical, some of them cultural, some of them legal. I think historically, if you look at where China has come from, you had unprecedented economic growth over a very short period of time. And it happened during a time where technology was relatively accessible. And so the ability to create pirated software was relatively available. Couple that with the culture that didn't really, and still doesn't completely, view intellectual property as real property, as something that to be valued, and put those together, then from a historical perspective, that develops into a country that's looking for a way to, like any other country, make money.
What advantages have you seen for companies using some kind of IT compliance software, such as SmartFlow?
First of all, if you have a compliance program, a compliance regime, then you're going to have an individual who's responsible for that. You're going to have a company that's responsible for that. Why is that important? Well, when you get time to be in court and you have to prove these things, if you have someone that's part of their business is to monitor these things, that person is going to be viewed as someone that can testify about these issues. Second of all, you're going to have objective evidence. You're going to have evidence such as IP addresses. You're going to have MAC addresses. You're going to have things that you can actually tie to the infringer that you can use to prove and ultimately stop or get an effective remedy.
And lastly, can you tell us the limitations and the opportunities for companies attempting to prosecute piracy in China?
I think there's obviously challenges, right? I think the opportunities are there for a number of reasons. Number one, the fact that it's happening suggests that at least there's a market there that wants to use your software. And so to the extent you can convert those to paying customers, obviously that's an opportunity to grow revenue. The ability to stop companies, there's challenges if you're trying to do that, but there are remedies available. There are remedies available in China through the Chinese legal market, and sometimes you can use some evidence that you've collected here in the United States, either through U.S. discovery or through your own phone home software or things like that. You can try to use that in China. But there's also remedies that you can use here in the United States to go after Chinese infringers. We did that in a case I mentioned earlier for a company called AWR a few years ago, where you use the phone home software to come to a court in the United States and say, here you go, we've tracked MAC addresses, we've tracked IP addresses, we can connect those with specific computers, a specific enterprise software, or a specific organization that we know is using our software. And then you have a management or compliance program that can testify and authenticate those documents and say, yes, we know how these work, and this is evidence that this company is actually infringing. Now,
thank you, Guy, for sharing your insights today here at the SmartFlow Summit.